Okay, so on behalf of the League of Women Voters of the Morris area, I'd like to welcome all of you to our Women's History Month program this evening. And we are delighted to have two really knowledgeable speakers talking about the Equal Rights Amendment who can lead you through a whole lot of the trajectory of this amendment. And so first of all, I'm going to, Molly Gonzales is with us via Zoom. She was planning on being here in person, but her car broke down this afternoon. And so thanks to the wonders of technology, she's still able to participate with us and did not have to do the, it did not have to deal with the car that was towed and is now she's a much safer condition. So we're happy to have her. So Molly is the Advancement and Civic Engagement Manager at the Alice Paul Center for Gender Justice. This is a federally protected historic landmark that is based in the childhood home of suffragette and Equal Rights Amendment author Alice Stokes Paul. She serves as the ERA expert at the Alice Paul Center, regularly delivering presentations, programs, and lectures about constitutional gender equality. Before working at the Alice Paul Center, Molly received her Master of Arts from American University in Ethics, Peace, and Human Rights, and her Bachelor of Arts in Political Science and Gender, Sexuality, and Women's Studies from the University of Pittsburgh. So we've got somebody who is well-schooled in the topic that we're talking about. But I'm also very happy to introduce to you Roberta Francis, Bobbie, to all the rest of us, who has been an advocate for the Equal Rights Amendment ever since the ERA triggered her feminist clique back in 1977. In the late 1990s, she was chair of the ERA Summit, the national volunteer organization that developed the successful three-state strategy for ERA ratification. In 1999, she became founding chair of the ERA task force of the National Council of Women's Organizations and set up the ERA website, www.equalrightsamendment.org, which she handed over to the Alice Paul Institute in 2015. Also, as Women's Issues Director on the State League of Women Voters Board from 1981 to 85, she led the reproductive rights study that resulted in an LWVNJ pro-choice position in 1982 and the LWV-US pro-choice position in 1983. Bobbie served as director of the New Jersey Division on Women from 1990 to 1994 in the administration of Governor Jim Florio. She is now ERA education consultant for the Alice Paul Center for Gender Justice. So I'd like to turn it over, but before I do that, I want to also acknowledge our two co-presidents, Kathy Abbott and Patrick Brown. Thank you. Everybody else for being here, and I'm now going to turn it over to Bob.
Thank you. I should say, you know, I feel so at home here. Every time when I'm in a League of Women Voters meeting, it's home. It feels like home to me, as the song goes. So thank you. And I know that what we're going to talk about tonight is right at home for all of us. And sometimes we like things even more complicated than they have to be. And that's what it is with the Equal Rights Amendment. So you'll enjoy this. But what we're going to start out with, Molly and I agreed, is that I'm going to do a maybe 10-minute, some of my introduction covers it, but I was going to talk about how I got involved, what I've done with the Equal Rights Amendment, and essentially why I'm still doing it at the ripe old age of and that's better than how I usually say it, isn't it? 80? Anyway, Molly will then talk about what she's doing with the Alice Paul, Paulsdale. How many of you have ever visited Paulsdale? Has anybody done it?
I think I have.
It's down in Mount Laurel. It's fabulous. There are about 4 or 5 staff members. Anyway, they are running a fabulous program there, Leadership for Women and Girls. It was saved from being sold in 1984 or 5. You know, housing developments grew up all around it, and if it hadn't been for, I will give credit, Barbara Irvine and some other people down in central New Jersey, it would be a housing tract right now. But it's fabulous. It's been designated a National Historic Landmark, and I really encourage you to take a trip down there. It's about an hour and a quarter, the way I drive, about an hour and a quarter to get down there. And in any case, Molly will talk about what's going on there with their leadership programs and their commitment to the Equal Rights Amendment. I mean, talk about a commitment. They are housed in the building that Alice Paul grew up in Mount Laurel. So it's all very powerful. And after we do that, we'll open it to questions. The first one, Rozella, I think, is going to ask me a leading question about where we stand now relative to the title of the program. The Equal Rights Amendment is the 28th Amendment. So I put in the introduction that the ERA triggered my feminist clique because I was in college from 60 to 64, was very turned on to the civil rights movement, racial justice. I think that's what got my social justice button lubricated, if you will. But I never got it. It was clear that the discrimination on the basis of race was a system. But I never got it about sex discrimination as a system till about a decade later, more than that. We had our daughter who was born in 69, our son in 73, and by about the time our son was born, I joined the Chatham Borough League of Women Voters. I don't know how many different leagues there were in what is now the League of the Morris area, but there were borough and township leagues in Madison, et cetera, et cetera. And somebody asked me in the league files, do you have anything about the ERA? And when I read it, I said, I've called it the most naive question of my life. I said, what's to argue? Of course, equality of rights shall not be denied or abridged on account of sex. What's to argue? 50 years later. So I know we all can identify with that. I worked through the league. I ended up on the league state board from 81 to 85, and that's when we adopted that study of reproductive rights at the 81 state convention when I got elected to the board. So I had either baptism of fire or I was thrown into the deep end of the pool or something, but I had to learn all the process of doing a study and reaching a position. But boy, was that a great education for me on both the substance of it and process. I cannot give the league too much credit for how I've learned about governmental process, organizational process, et cetera. So in any case, and it took me many more years before I truly understood the connection between equality of rights under the law and reproductive autonomy rights. But that is coming together much more clearly, especially as particularly reproductive rights have been attacked. It's very clear. And in some states, they're doing state ERA protection of reproductive rights. So it's coming together. But in any case, I kept working on the ERA. I did, when I was director of the State Division on Women from 90 to 94, at some point there, Barbara Irvine, the Alice Paulsdale genius, was already attending a group called the ERA Summit that met down in Washington, D.C. every few months at the Sewell Belmont House. Has anybody been to the Sewell Belmont House in Washington?
Walked around the outside.
Yeah. Oh, stunning. It is now a National Park Service site and cannot recommend highly enough to go visit that as well. Right now, in fact, Molly could say it too, but the National Women's Party, which was Alice Paul's party, finally, just within the last 10 years, I'm not sure, Molly could maybe correct, but did finally go out of business. They first of all had to keep up that house themselves on private funds until sometime in the 90s. It was, well, they were helped with some grants and some Park Service money, but anyway, now they gave it to the Park Service. And the Alice Paul now called Alice Paul Center for Gender Justice. It started out as a couple different names, but Molly's organization down here in Hallsdale. As the National Women's Party merged with that, so it's an interesting historical kind of evolution of very important women's rights efforts. All of this to say that the Equal Rights Amendment is just inextricably joined with Alice Paul Center, with me. Molly, bless you, is filled with the same passion that's kept me going for all these decades. And so it feels really good right now, even though it's always been an uphill battle. It will always be an uphill battle, and the League knows that better than anybody, almost any other organization. One last question. Has anybody here seen the musical Suffs? Oh, I love it. I love it. Sam, my husband Sam. We've seen it 3 times. Love it more every time. We saw it on Broadway, but now the touring company has been, we saw it in Philadelphia in January and up in Boston just last month with our daughter and our granddaughter. And oh gosh, the League particularly, anybody who loves what the League does should go see that and be lifted up to the whatever. In fact, it's in DC. The touring company is going to be in DC in June, and Sam, I haven't mentioned it, but he might try to go again. But that is just, I mean, it's Alice Paul there, center stage, literally. And I think that Alice Paul, whom I love, is a little more bubbly than Alice Paul herself ever was. Not Molly's nodding, but Alice Paul herself is the way we all have to have some part of us, and that's eyes on the prize, if you will. You have to just say it does matter, of course, but whatever they throw at me, I'm going to keep going. And oh, I just thought of the last song in that where it's keep marching on, and just you can't go out of the theater not having that going through your head. So I think that was background, and I think it's a good way to lead into what, I don't know how many generations between us, at least 2, 3, but what we still are, what these issues inspire in people, and women and men, and why, as Susan B. Anthony said, failure is impossible. I wrote an article that was in the Online Biz about a month ago, and my last sentence was, success may never be linear or complete, but failure is impossible. And I think that's what keeps me going. Well, I was just going to say, we can hand it off and then we'll.
So let's give Molly a chance to share some of her insights, and then we've got a few more things that we want to talk about.
Well, I'm so excited to be here, everybody. Thank you so much for having me, even though I'm on the screens. I love the story of Bobbie's feminist clique. I actually think about it a lot when I'm on site at the Alice Paul Center, which is a museum and an archive of Alice's personal papers. I think about Bobbie going through the files at the League of Women Voters to learn about the ERA. Every time I'm in the archives upstairs, I think, well, what other ERAs are buried in here? What other little feminist threads do I have to follow here? And I think about how only 3.5% of federally protected landmarks are dedicated to women. And most don't have archives, especially not on site. They get gobbled up by bigger institutions. And so how many more opportunities are there for people to have that feminist clique if the materials themselves don't exist? I was very lucky, well, maybe not for what I'm about to say. I had my feminist clique in high school. I was not very lucky about well, I'm trying to be nonpartisan here, but we're all amongst feminists. I was not very lucky when I went to high school that day to see that Trump was elected. I was 17, so I couldn't vote. And it had never occurred to me, really, that there could be people who really believe this. Could there really be people who believe this, right? The kind of rhetoric that was being said. I'm from a city, so I thought, gosh, well, there's no way people are going to buy this, right? But of course they did, right? And so I then learned about the ERA when I was in college, but I was totally lied to in this women's history course. They totally lied to me. They said that the ERA was was a movement of the past. That the ERA is not around anymore. It died. The time limit went past. And don't worry that the time limit is not constitutional. Don't worry that they were throwing all of these. I mean, they ripped up the rule book to try and defeat ERA. They didn't play by the rules. Anybody involved, right? Don't mind that. Just forget about it, right? And so when I started working at the Alice Paul Center about 3 years ago, I got really stuck on ERA for a lot of reasons. One of them is this like issue of principle, right? Of this is the only proposed amendment to the Constitution to meet all necessary requirements outlined in Article 5 to not be published. It's ratified. It's already been ratified. It just hasn't been published. And this is the only one. And, it's not a coincidence that this is the amendment that would make gender equality the law of the land. Of course, right? That there are so many politicians dragging their feet in the mud. I mean, something that also shocked me learning all about suffrage is that after the 19th passed, there were like hundreds of male lawyers and scholars and politicians, but also just like everyday men who sued the government to prevent the 19th from being enacted. So it was already published, right? They were just furious that, gosh, if women could vote, what else could they do? They could serve on juries, they could have houses. And so all of these men sued. So we know that the constitutional amendment process is messy and choppy and doesn't always go according to plan. And I think with the ERA, that's especially true. I also love drama and gossip, and so the ERA is a fabulous place to study. Is a fabulous thing to study because there's so much drama. There's not a boring moment in the 103 years that the ERA has existed. Not one of them were boring or nothing happened, right? I mean, they try and sell it as, well, it didn't pass Congress until the 70s. It wasn't making a lot of headway. Of course, there was so much happening during this time. Are you kidding me? There's what the National Women's Party was doing as researchers and scholars and activists, all of the advocacy for ERA, the way that it, like a chameleon, was able to change according to the times. Like water, it was able to kind of move and have this fluidity. That's so exciting and incredible, and a task that most amendments just didn't have to go through, right? The 27th Amendment, which is the last amendment that has been ratified, was ratified in 1992, which means nobody in America who is under the age of 40 remembers what a ratification could mean. Nobody under the age of 40. They don't remember it. They haven't seen it. Maybe they were 5 years old and didn't know what the Constitution was, right? So for a lot of people, this doesn't feel like a reality because they can't see it, right? And throughout the 20th century, throughout the centuries previously, that wasn't necessarily true, that the amendments with some generational regularity were being ratified. But for everyone under 40, this is a completely foreign concept. They have not seen it happen before. And so a lot of the work at the Alice Paul Center that we do around ERA is public education, going to schools, going to workplaces, teaching people about the ERA, because a lot of people don't know about it. A lot of sharp people who you'd think would know about it don't know about it, right? A lot of people aren't aware that it's the only amendment that hasn't been published to meet all necessary requirements. A lot of people don't know that it was a bipartisan issue, that both parties endorsed it for most of the ERA's history. They don't know that it is one of the most popular proposed constitutional amendments in our history. Like all of these things people don't know. And so our job is education, to teach people about the ERA. It's important, of course, because Alice wrote it. It's also important for our organization because the Alice Paul house, the Paul family home, was saved by ERA activists, women who were passionate about the ERA. The ERA can mean so many things and stand for so many different issues. But it is this galvanizing force that has succeeded in so many ways, preserving women's history being a small, but in my world, huge part of it. A lot of the other work we do is involved in kind of training the next generation of Alice Pauls. A question I get a lot is, well, who's the next Alice Paul? And I'm like, well, they are meeting every month at the Alice Paul Center for our Girls Leadership Council, which is an after-school feminist club for high school girls. Every month they have a different issue that they learn about, and they work on a service project, and they have a safe space to kind of understand the world around them. They have a safe space to talk about what's happening with this president, what's happening with the Epstein files, what's happening with so many issues where as teen girls they feel unsafe, right? the Alice Paul Center has that place for them to feel safe, to movement make, to toss around ideas and try and see what sticks. To raise the next generation of National Women's Party members, of Alice Pauls, of Lucy Burns, of Ida B. Wells, all of them, training, not just their knowledge of feminist history and their knowledge of the Constitution, but their confidence. One of my favorite moments out of GLC was this young girl named Mia who said that she had never raised her hand in class before, and now nobody can get her to shut up in class. That she knows the material well, right? She reads all the books, but she had never raised her hand in class. And it's moments like that, right, where these women, these young girls who are going to be women very soon, like the confidence that they now have in themselves, I think is one of the most important things, especially to be in a building where you see these big, beautiful posters and museum tags of all of the ways in which women have created democracy, are the reasons we have democracy, all of the ways that women have been the keepers of democracy and the expanders of democracy, that women are the reason that we have movement-driven amendments to the Constitution. You think men could come up with that? I'm sorry, gender equality is important, but it's women. It's women who came together to amend the Constitution from a movement. The 27th Amendment, to quickly go back to that, I don't know how many people are familiar with the story, but it was an undergraduate male student who wrote about the Madison Amendment, which was one of the 12 original amendments proposed in the first Congress. Of course, only the first 10 become the Bill of Rights. We know the whole story. And so it's this one single guy who goes on this campaign. And I think what's beautiful about the ERA and the feminist movement is there's no such thing as one single person, right? It's a movement of people together pushing it forward. And so the ERA has become sticky for me for all of these reasons and more. And because it feels like one of our last chances at securing democracy here and securing women's history as a women's right. So that's how I would answer that. And I'll turn it back to Bobbie.
So let me just go back to this before you speak, because Molly talked a little bit about the 27th Amendment, but I don't know how many people really understand the significance of what happened with the 27th Amendment, which was actually proposed as one of the 12 amendments that the Bill of Rights, the first 10 amendments, came out of. And this college student back in the 1990s discovered that it had never been added to the Constitution, and it became the 27th Amendment in 1992 while the ERA was out there floating around. And when we talk about time frames, would you please talk a little bit, Bobbie, about the time frame involved between the passing of the 27th Amendment and what the ERA advocates were talking about around that same time? Thank you.
I certainly will. Thank you. We emailed back and forth a little bit about it, and Rozella said, I never knew that story. But the 27th Amendment is housekeeping almost. It says that Congress, if it votes itself a raise, can't collect it until it has gone through a general election. So if they, double their salaries and the electorate doesn't like it, they have a chance to vote the bums out before they get their money. It's not a big deal amendment in some respects, except for keeping the decision-making in the electorate rather than the elite. But 2 of the 12 articles that went out to be proposed amendments didn't get ratified, and the Madison Amendment, it ended up being called because it was in James Madison's time that it was proposed, had a handful of ratifications for almost 200 years. It didn't get into the Constitution, not because it was being blocked, it's because states didn't ratify, not many states ratified it. And so in maybe 90, I don't know when he started, but late 80s anyway, a young man who was at the University of Texas in Austin wrote a paper for his history class about the fact that this amendment, while it doesn't have many ratifications, was still alive and still the ratification could be finished. And he got a C on it. And his history teacher said, nah, no way. And he just got mad enough to say, I'm gonna politically see what I can do here, and he did it. I mean, not only he, but they ended up getting all the necessary 3/4 of the states, 38 states ratifying it. And one part of the story I really like, I forget if I shared, was that his history teacher, professor, wanted to raise his grade to an A. And he said to her, no, I don't want that. I don't want it to disappear that you really didn't grade this correctly. So, but in any case, that at that time I was attending these ERA summit meetings in Washington. And the two women, a generation older than me, who were had worked on the ERA for a long time, Allie Hickson from Kentucky and Flora Crater from Virginia, suburban DC, had worked forever, far longer than I had on the ERA, and they both said, and others were saying it in the summit, well, hey, if 203 years isn't too long, nobody can say the ERA's first ratifications in 1972 are. Even though the difference was that didn't have a time limit, the ERA did. No amendment ever had a time limit until Prohibition. There's so much interesting history here, so many paradoxes. I should have said to Sam, I've written up a sort of summary of where the ERA is right now, is the 28th Amendment. And one of my sentences is essentially frustrations and paradoxes abound. So that we all know that's the story, but so anyway, that 27th Amendment is what triggered the thinking of the ERA summit leaders in the 90s. We were saying, and we didn't even know if it was accurate, but we said anything that gives the ERA more visibility right now, that was pretty much the doldrums in the 90s. So we started promoting the idea that, well, the 38 existing ratification, I mean, the 35 existing ones out of the 38 needed could still be valid. Maybe we can only, maybe we only need to get 3 more. And that's why we call it the 3-state strategy. And we didn't get much support. The ERA summit had attendees from a lot of the major women's organizations. And many of them didn't think it was very plausible. Those of us who kept pushing it weren't sure how plausible it was, but we kept saying it's just kind of, we didn't say it was just placeholding, but the idea was let's just keep the ERA visible. And if it does nothing else, it will help set up the next time we go for the starting over strategy. And there were bills in Congress. Have you heard of Carolyn Maloney, who is, she's not in Congress anymore, but she was the lead ERA co-sponsor from mid-90s until I guess she was just, what's the word, but redistricted out of her district in central Manhattan 2 elections ago. But in any case, Carolyn picked up with this, but she was always reintroducing the start over strategy. After a while, and does anybody remember the name Rob Andrews, who was a representative from central-ish New Jersey? He was a constitutional lawyer too, and very pro-ERA, and Barbara Irvine, again, I invoke her name, had a lunch with him one time and told him about this strategy, and he got very interested just kind of as a constitutional lawyer as well as an ERA advocate. And so he put in the first bill in the early, like it was maybe 04 or something, that said, when 3 more states ratify, the House of Representatives, that's where he was, he couldn't say not Senate, but House of Representatives will do whatever is required to affirm the ratification is valid. And so that's what started getting things moving a bit. And eventually a bill was put in maybe 10 years after that in both the Senate and the House that was more specific. It said, and there's still bills in right now, it said notwithstanding any time limit, the ERA, now it says, has been validly ratified because now we have the 38 states. So that's where we stand. And what I want to go over for just a few minutes, and I don't want to, it's confusing enough, as I say, so I have my little cheat sheet here and I want to just run through it. But as Molly said, the ERA has met the 2 requirements of the Constitution's Article 5. You have to be past in both houses of Congress by a 2/3 majority, and it got way more than that in 1972. And you have to have state ratifications from 3/4 of the states, 38 out of 50. It just got that in January 27th of 2020. January 27th is my husband's birthday, so I never forget the day. And 2020 is, I thought, oh, right before the pandemic really hit. I don't know if they dodged a bullet by getting it through then. I'm just glad they did.
Which state was it again?
Virginia. The 3 states after, well, it was introduced with a 7-year deadline in 72, that would have been ending in 79. The year before that, it was the Reagan pendulum, the Republican pendulum with Reagan. Reagan removed a 40-year support, the Republican Party platform for 40 years that supported the Equal Rights Amendment, both parties had. And when Reagan was elected in 80, they took it out of the platform, and he said they would just do it in state, not a federal amendment, just state by state, they would improve that. And Barbara Mikulski, many of you probably remember the name of, Maryland Senator, Barbara Mikulski said, well, that's as if Lincoln didn't, he said, he would have said, we don't need the Emancipation Proclamation, we'll just free the slaves plantation by plantation. So that's about how I agree the way that strategy went. But in any case, the Republican support that had existed, Alice Paul was Republican, but we all know how the parties have flipped. It's like the poles of the earth, magnetic poles flip every so often, that the parties are now the opposite of what they stood for when she was a Republican. The 35 states that we got in the first 10 years, it was up, there's 7 plus 2.5 more. By that deadline, extended deadline of June 30th, 1982, there were still only 35 of the necessary 38 states that had ratified. And there we sat for almost 40 years, from 82, let's say, until a lot more energy started building up, both support and, we know, opposition. It's become more divisive all the time. And this was the first state that ratified, based on the arguments, some of which I'll tell you here why I contend many good people like Lawrence Tribe say it is ratified. It was a difficult slog, and it was not till 2017 that, I say it the way they do, Nevada. I do now, I didn't know two before, but they agreed. They had a legislature that I think for the first time ever was majority female. They had some very positive elections there, state elections, and they got it through and ratified it in 2017. Illinois, which always should have ratified it before, but which had imposed a 3/5 vote standard for ratifying, it was because of the antis. Illinois then ratified in 2018, and Virginia on January 27th, 2020. And so when the 3 states ratified, that meant what Article 5 said. The big issues that were raised were, wait, but there was a time limit. And also, well, over these years, 6 states voted to rescind or otherwise withdraw their ratifications. Guess what? When I say we, constitutional lawyers, et cetera, have good reasons to contend that neither the time limit nor the rescissions can, pardon the language, trump the fact that the ERA is ratified according to Article 5 of the Constitution. And just briefly, I want to leave plenty of time for questions. So for a few minutes, I will tell you why I think the plot is very thick right now. The reason, 3 weeks before Virginia voted, everybody knew Virginia was about to vote. Everybody figured Virginia would ratify. So the archivist named David, spelled Ferriero, and people have told me it's pronounced Ferrero. I don't know if he doesn't know how to pronounce his name or what, but I'm not happy with the man, you can tell. Asked for, and this is appropriate, he asked for the Department of Justice's Office of Legal Counsel to issue an opinion about what the archivist should do when the law says the archivist should publish, but there have been decisions and a time limit. And what the first Trump administration's Department of Justice under Bill Barr said, you think it was for the ERA or not? Said that the archivist could not publish because the deadline had expired and that Congress, which also from precedent, I can explain why, should be able, there's no reason they said this, that Congress had no further role in the process. So the archivist said he would comply with that advice unless a final court order directed him otherwise. And then when Biden came in, there was another OLC opinion, which was very frustrating for us because they did not retract the comment about the time limit. They still said that the time limit meant you couldn't publish, the archivist couldn't publish. But it did say that Congress and the courts still had roles in further dealing with the amendment. So anyway, it's, you know, dueling opinions. And what I just found out yesterday was did any of you see the thing about the current Department of Justice Office of Legal Counsel saying that the Presidential Records Act is unconstitutional? Did anybody see that? No. Just yesterday. They are talking out of everywhere. But it turns out, and I just found this last night, I told Sam this morning, that's what I read right before I went to bed last night. That a legal opinion from the Office of Legal Counsel and the Department of Justice is binding on the executive branch, and only the executive branch, but the executive branch. Meaning, and the archivist is an independent agency of the executive branch. So in a way, which until yesterday, I thought, well, the archivist is just breaking the law by not following the law that requires immediate publication. Excuse me. I get all upset.
Yeah.
But anyway, right now, I'm gonna be working out and talking to legal people who might talk to about putting together all the facts. But I think right now, my contention is that it's just one more frustration. It's not a stopper. That the archivist can't just say, well, the law tells me to do this, so forget what the legal counsel's opinion is. The archivist must pay some attention to that, but we'll be working that out. I can quote things, I mean, I have quotes here from the website of the archives, all kinds of things. But right now, I'll just wrap up by opening into questions for Molly and me. Oh, somebody should write a song. And we can talk about some of the other things I have in here, but I guess I want everybody to know that by the Article 5 of the Constitution measure, the Equal Rights Amendment has been the 28th Amendment since Virginia voted on January 27th, 2020, over 6 years. And it's for various reasons, people have pulled out of their hats, or maybe some need to be pushed back against. It's been blocked from being published and put in the Constitution and implemented. So no other amendment has done that. And you know, we are used to it. Those of you who've seen stuff know what I'm talking about. That took 72 years.
So my next question, before we turn it over to the general questions from the audience, is all of the energy that has been directed most recently towards the SAVE Act and the discussion about what the proposed SAVE Act would do to the role of women as voters. What impact do you think that energy being directed by the SAVE Act may have on the movement to get the ERA published?
I think they are, you know, the energy to defeat the SAVE Act and the energy to get the ERA published are the same energy. And if we could bring some of that together, that would be good. I keep saying, I'm not a lawyer, but I play one on the ERA, but I do not know exactly whether there's a distinction between a law's impact and a law's intent. I don't know how many of you, maybe, are any of you lawyers too? But anyway, I have to have to find out more about the fact that the ERA would obviously say quality of rights may not be denied or abridged on account of sex. But if a law is able to be interpreted as having disparate impact, but not disparate intent, it might succeed in being upheld. So I'm not positive about that, about the SAVE Act, for instance. But of course, we all know what the intent of it is. But however, if it's not on the face of it, if it looks like just disparate impact instead of disparate intent, I don't know how a court would deal with it. But let's get that energy together.
Yeah, there's something if I could just add quickly about the SAVE Act that I think is important here is that like since 1980, women show up to the polls more than men by like huge numbers, right? Women vote more than men for the past 50 years, right? Women vote more than men. Okay. They know that. The people who are the architects of the SAVE Act, they know that, right? That's very purposeful information that they're aware of. And so I think any limit on when there are movement drives to expand democracy, expand equality, to make these principles, which are founding American principles, bigger and more expansive, there's always going to be a restriction because there are people, ruling the ruling class, if I'll say it, like are scared of their own power being taken away. But of course, like that's not what's happening here. I'll also say that I agree. I think that like the rallying around the SAVE Act can be could pose as a feminist clique for a lot of people. A lot of people not knowing like my voting right, rights that we may take for granted when they're on the chopping block. I think it offers potential for more radicalization and consciousness raising and like we all understand the intent of the architects, but what they don't understand is that they're going to create more feminists in doing this. Like they're going to create more feminists in doing this because for the first time ever, women are going to realize a right they thought they were born with is actually at stake. And if a right you thought you were born at is at stake, it means that the society at large, there's some system here. It's not just one guy, it's not just a couple guys, it's a system here. And so my positive spin on the SAVE Act, which one must have a positive spin on everything right now, is that I think it's going to create some more feminists, a lot more feminists than if it didn't exist, and they're not going to let it go through. And yeah, I hope that made sense.
So I think that you should just ask your question there because there are microphones and the ceiling should pick it up. But if we can't hear you, then Jamie will bring you the microphone. So let's start with that. Sandra.
Molly may have answered this, but I'm having trouble hearing her, so I'm sorry if it's being repetitive. But who or what body determines whether the amendment can be published?
It's the archivist. It's the archivist of the Library of Congress.
Independently?
And so the archivist of the Library of Congress is somebody that the current administration has played around with.
I see.
They have eliminated that. They fired one person. They appointed Marco Rubio to do
Another job. He did that for a year. He just stopped in February.
And now there is a new person there, but we know that the people who are being appointed right now to positions, to government positions, generally are in agreement with the administration. They're not, they're,
Sure.
but that's not gonna be that way forever. Okay, other questions? Yes.
Well, before, I'm sorry, let me do a friendly amendment to that.
Okay,
It's not the archivist who decides it. The archivist is supposed to follow the statute one USC 106B, I have it memorized, that governs constitutional amendments, and it says, if I can find it, I wanted to just look for, but as soon as the final necessary state ratifies, the archivist shall forthwith, which in legal language means must immediately, perform the ministerial duty. That ministerial means allowing no discretion to choose not to act. To me, there are no loopholes left here. And ministerial act of publishing in the Federal Register a certificate of ratification with a list of the ratifying states, triggered by when the final necessary state votes, which is why I say from January 27, 2020, it's the 28th Amendment. However, that publication in the Federal Register by the archivist, which is not his choice, a decision or an option,
Right.
It's not discretionary. That's what triggers having it printed in the Constitution, having it be implemented in the courts, having it be put into legislation, shoring it up. The second of the three short sections of the ERA says the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And so, of course, Congress isn't being told it has to do that or has the option to do that and at this point. But it's not as though somebody, except in this circumstance, has to say, now you may publish. It's that the law tells the archivist that he, she must, and it's been a he and then a she since this all started in 2020. The archivist just is supposed to follow the law, but when the archivist is not following the law, at this point, it's because of those Office of Legal Counsel opinions. And that's where we're sort of stuck, but never stuck. There's always another way around. I mean, three-state strategy was another way around. All kinds of things. And it's going to be same as with suffrage. Those of you who saw suffs, 72 years, and we got it.
So
We're gonna get
why didn't this happen during the Biden administration?
Thank you for
Question.
What, in fact, let me read you. My first fact sheet about why it's ratified, I wrote back in the last couple months after the election of Trump for the next second term, and we knew Biden was lame duck. We worked our butts off trying to get through to his White House counsel office and saying, first of all, the executive branch, the president, have no role given to them in constitutional amendments. So it's not like he can dictate to the on the legislative side, if you will, or the constitutional amendment side. But he does take an oath in his inauguration to what's the preserve, protect, and defend the Constitution. Some of us memorized that, right?
Mhm.
And so the Constitution says that the president has the duty to take care that the laws be faithfully executed. So that means to me, and I would think a lot of, in fact, I know, Russ Feingold, does anybody recognize that name? He was the senator of Wisconsin for a long time. Last year, he was president of the American Constitution Society. And through the National ERA Coalition, I got a connection with him, and he's been very supportive. He helped get the fact sheet into the White House counsel's office 3 weeks before Biden was out, but it did not get picked up on. What Biden did do was on the last day, I don't know if anybody remembers, on the last day, he issued a statement, January 17th, 2025. Today, I'm affirming what I have long believed and what 3/4 of the states have ratified. The 28th Amendment is the law of the land, guaranteeing all Americans equal rights and protections under the law, regardless of their sex. That and $4.95 get you a cup of coffee. Almost. Were people who thought, legal people, positive people who wanted to see the ERA shored up better than that, still said this made a difference, makes a difference. Show me that, I'll believe it when I see it.
Mm.
But it was very frustrating.
Yeah.
That was basically my question as well, like what happened in that last flurry of the last week of the Biden administration.
Oh,
But I remember that the directive and what we were told to write was to ask him to ask the archivist to publish.
yes.
And he never actually took that step. Do I remember that correctly?
You do, not except on your account, but I always thought that message was a little bit of a excuse for them to say, we can't do that because the executive branch president has no role. And so it's not like he could order the archivist to publish but the statute does that. And he could say that statute's not being faithfully executed. That was what my fact sheet, it's not me, but with the support of legal minds and so on. But I think what he could have done and had an effect was to say, and I don't know how to do it, the White House counsel would have to find the right way for a president to say that law is not being faithfully execute. But that's what I think the language should have said somehow. But if they wanted to do it, they'd have found a way to do it, so.
Yeah, so if I could piggyback off of that, oh, sorry.
Just want to do it
I'm
anyway.
sorry, 1 second. Are you speaking now, Molly?
Yeah, if it's okay to piggyback off of that, I think something that's also kind of like important to know a few like one that the National Archives is not that's not even a century old. That was a Depression era policy that created the National Archives. So a lot of amendments didn't need that final step, that ceremonial step, right? That actually the executive isn't supposed to be in the Constitution at all. It's by the people for the people. And so maybe Biden could have put the guy who was the president before him, he could have put him in jail for desecrating the Constitution, because that's what he did, right? Like there's so many other ways that could have been pushed forward while honoring these values, right? And what ended up happening was the Friday before he left office, an executive opinion was released, and um, the White House website after the weekend, when the new owners took the keys back, scrubbed the website clean of anything that had to do not just with ERA, but of Biden himself, right? The website's completely scrubbed. And so that opinion, which of course wasn't printed, it was announced too late to be even printed in a lot of different like physical papers, physically doesn't exist, right? It was virtually scrubbed and physically doesn't exist. And I think that's a really important note here, the choice of timing, how, ERA activists didn't call him that Friday. They called him years ago before that Friday, right? But it because of, the slowness, the resistance to feminism within elected office at a lot of different levels in this country, because of so many different factors, right? It got scrubbed. And so, it's like cultural and social importance, but then when the time comes, what we need is legal and political importance. And those two former, right, not enough change to get a sandwich, right? Like it's just short. And so, of course, it's hard to measure cultural and social change. Pretty easy to measure political and legal change. And so, he didn't do enough. I think everyone knows that, and it's frustrating. But it reminds us, I think, as feminists, that ultimately it's feminists that get this done. It's not one guy. It's a movement of women. And so that's I I think it's painted as if, oh, we've always had the National Archivist publish it, right? That's just how we do things. But that's a really new ceremony. That's really new. And nowhere in Article 5 of the Constitution, which is our little like, here's how to amend it. We got two sentences from the founders on how to do that. The archivist isn't mentioned, right? There's no ceremony. It's exactly what Bobbie said, 2/3 of the House, 3/4 of the states. Like, kind of, pretty simple. Obviously, it's not, but yeah, I think that kind of puts more texture into the final moments of ERA under the last administration.
Thank you. Okay, over here.
I have no idea what Molly said. I also can't understand her. I'm very sorry. But
Maybe a little slower.
Yeah.
I don't know.
If there's some kind of
It
feedback
sounds
or something, that's just hard.
What she was basically saying is that the office of the archivist is a fairly recent 20th century office. It wasn't there at the very beginning, and it's not part of what the Constitution actually says. The Constitution lays very clearly out that an amendment is passed when it's passed by a 3/4 vote of both houses of the Congress and 38 states ratify it. So the fact that we're waiting for an archivist to make an announcement is not what happened with so many of the other amendments. Well, this is recent.
So it's just necessary.
Well, the twist on it,
Isn't it?
it's not necessary to affirm its ratification. It's not necessary to ratify it. It's not part of what an amendment must go through. It is necessary, as we see, to have the ratification be formally announced to the world and then printed in the Constitution and applied in the branches of government. And that's where we've hit. Why a slight amendment too is that there were people performing that function before it was the archivist. It was the Secretary of State who did it. And the Secretary of State would publish it. We know from the suffrage amendment that when Tennessee was by one vote, the final stage, they hurried to get the record of that vote to DC, and the Secretary of State, whose function it was at that time to publish, or he issued the certification, which is what gets published in the Federal Register. The Secretary of State issued the certification before breakfast on the day he got it in order to head off any more resistance to it. Why are they so afraid of women's equality? It's the
So what do-
patriarchy.
what do we do now?
That's what I would say.
We just
And
wait.
not men, the patriarchy. It's a system. It's another system.
So what do we do now? We just work for a Democratic president who will have an archivist who will follow the law. So faithfully, we come back 3 years, hopefully.
May I read my little?
Democratic president,
Why was
and it
it?
didn't happen.
Oh, I'm sorry.
But we had a Democratic president, and it didn't happen.
But they didn't, he didn't do it.
Well, but I think we all need to be politically savvy. We know the league is political but nonpartisan.
Correct.
And I didn't take me long to learn the difference, but we always have to remember that. Political, I mean, this is an overstatement. Almost anything you do around public life is political. It's the power of the people. And, but partisan is literally, I guess, associated with parties, but it's associated with how parties relate to stances along the political spectrum, and so on. But in any case, what I want to share in terms, I have written this up and hope to get it published. After I stopped reading things at midnight and finding, I was up doing Wordle last night and read this about the OLC thing. But there is a very, very important thing pending in Congress, and it has precedent, and we hope by next year, and that does get into who is in the next Congress, if you want to call that partisan, but if the next Congress agrees to do this, I mentioned a Rob Andrews thing and the different bills way back about if 3 more states ratify and Congress will do whatever required. Twice before in our history with the 14th Amendment and 15th, we know those civil, around the Civil War.
Reconstruction Amendment.
Yeah, Reconstruction Amendments, thank you. There was great dispute and controversy around the 14th because one of the ways that it got ratified was that the southern states that had seceded were told they couldn't rejoin the Union unless they ratified. As I understand it, that's literally how it happened. But anyway, they had stipulations for the southern states, they had to ratify it, so on. So there was, some people didn't like that. And what happened then, and with the 15th Amendment, which was the right
to
the vote shall not be denied on account of race, color, or previous condition of servitude. New York voted yes, and then withdrew its ratification. With the 14th, there were New Jersey and 1 or 2 other states voted yes and then withdrew them. And those rescissions, I should say, were not recognized at all. Nobody even gave reasons why they didn't work. It's just that when the states that had ratified the amendments were published, they included those names. So rescissions have no precedent for being accepted. So the 6 states that over these decades have tried to rescind or withdraw their ratifications of the ERA should be not effective at all.
Yes, over here.
So not that we like it, but there was a 10-year limit on the,
I was about to get to the time limit, but yeah.
so the fact that it's passed now is wonderful, but there was a 10-year limit that you're ignoring.
Constitution.
That you can agree with it, not agree with it, right?
It's being put into context, and the context is Congress. I'll lead up to the resolutions in Congress for next year. But the precedent that with the 2 amendments I talked about, 14th and 15th, when there was this disagreement about whether the rescissions meant they didn't have the right number of ratifications, Congress in both cases passed what's called a concurrent resolution. Same wording in both houses, and a concurrent resolution does not need the president's signature. I looked this up. Joint resolutions do, concurrent resolutions do not. That's Congress, and it's called resolution, it's saying sense of Congress. And those Congress resolutions back then were saying, we accept, and they listed all the states that had ratified. and they say that this is a valid ratification, and that was the end of the controversy. The country just went on. There are lawyers who have written books about how the minority of amendments have gone through according to Hoyle, if you will, that there have been so many variations in processes of getting our amendments into the Constitution that it's almost, there must be some cliche that applies, but you know.
But it should have, because of it would have. But
Well, I'm gonna
I'm saying
get,
it's
talking
all
about the
those,
time
all those
frame.
I know,
things are, I agree with. It should have, it could have, it would have done this, and we could have done this, we should have done, but there was a 10-year time limit that
well, I'm putting it in the
Basically,
context of Congress's
you're not
power.
ignoring it, but it still exists and it voids out
I'm putting it into the context of what Congress can do now. And I'm saying that
what they could
Congress,
do, but they're not even close to doing that.
you know, like the Mets, one opening day at the Mets, somebody walked around with a sign that said, wait till next year.
Maybe not.
I love, which I love, that's just the Mets story.
Has there ever,
Wait till next year. And well, go ahead.
has there ever been another constitutional amendment that had a time limit put on it?
It doesn't.
But this is all the history and I have a lot of that in here. It's not mentioned at all in Article 5, neither are rescissions. Power is not granted, but maybe power could be. But if you want to add more requirements to an amendment process than the two in Article 5, it could be substantive enough that you can't have it interpreted and you have to pass another constitutional amendment. That's what happens with wanting to change the Constitution. So there's some legal issue of.
That's not what I asked.
Well, I know, what I'm trying to do is give the context for leading up to what Congress can do.
Good.
Ask your question again now.
My question is, was there ever another proposed amendment that had a time limit?
Started with prohibition, that's why I say I had to cut through. There was never a time limit on an amendment until prohibition in 1917. And that was that was because the people who voted for prohibition wanted to cover their tails and say, I'm voting for the dries, but I'm putting a time limit on, so maybe we won't have to stop drinking. They thought it might not pass. And they arbitrarily picked 7 years out of the air. I keep saying 7 brides for 7 brothers, 7 deadly sins. Why not 7 years for
So
the
did it get passed in that time
It
period?
got passed with a 7-year limit in the text that got ratified by the states, which is different. The ERA time limit is just in the proposing clause, not voted on by the states. That, of course, we know got rescinded by the 21st Amendment or something, but it did have a time limit. Then the next amendment that went out was, I think it was was suffrage. No time limit on it. Nobody put a time limit on suffrage. After that, it started just being a habit. They put a time limit on amendments. Everyone after that that's gotten ratified has had a time limit. A few for a while had them in the text that the states ratified, but then soon they started putting it in the proposing clause, which doesn't get voted on by the states. Maybe I'm going into too much legality here, but I think it matters to know the ERA doesn't have a time limit in what the states ratify. And there is every contention right now, and this gets me back to the Congress thing, every contention that Congress, as it did with the 14th and 15th Amendments, can pass a resolution saying the Equal Rights Amendment is ratified, it's met the two. In fact, the language of that bill, I think I did read, notwithstanding any time limit, it's ratified. And that bill's been in Congress 6, 7, 8, well.
It's been reintroduced several times.
Yeah.
It's never gotten
I'm
out.
trying to, yes, but in any case, it's in the Congress right now. I think this is optimistic. First of all, advocates of the ERA have been working very hard, and there are now 219 co-sponsors in the House of the bill that's in this session. If you know the math, 219 is 3, I guess, over the majority of the House members. So it's a handful, but if it's Republicans, because we Democrats, nonpartisan. The Democrats have what, 214 or 15 right now? So there are a few Republicans on the bill. And in the Senate, the chief sponsor is Lisa Murkowski from Alaska, who is Republican. But her strategy has been to want to have a Republican and Democrat paired for each sign up there, so they've had very few Republicans. One or two, one, I guess, the one with Mazie Hirono from Hawaii, are the only three sponsors on the Senate version of that bill. It's not, every Democrat in the Senate is supportive of it, but they are observing or, granting that the chief sponsor, Lisa Murkowski, can have her strategy, because it would not even be brought up for a vote in either the House or the Senate this year. And the leadership can put up for a vote whatever it wants or doesn't want. So those will not get voted on this year, which is why people aren't pushing all that hard. But to get 219 when you're not openly pushing that hard, it shows that the support is there. Next year, if it can be put up in both houses for a vote, and I think it's going to be a big priority. If we have Jamie Raskin chairing the Judiciary Committee, it's going to go through the Judiciary Committee like that. And so the answer to a lot that I've made longer than it needed to be is wait till next year in one sense, and in the other sense, know that Congress there's precedent for votes in Congress saying this amendment is validly ratified without going into details about time limit, although it's mentioned here, et cetera.
And so I think the answer to the question is, yes, there have been several 20th century amendments that have had a time limit, and the amendments have been passed within that time limit. I don't know, I haven't done any research on which amendments that were not passed, that were in it. But the question is that the time limit itself could be negated by a joint resolution. So you have to look at, there are amendments, there are bills, and there are resolutions. And they're all different actions for different purposes. And so when you were talking about a concurrent resolution, it's just a sense of the Congress. It's a sense of how they interpret it. So if there were a joint resolution for both the House and the Senate together at the same time, interpreting that 10-year limitation as not being important, then it could be waived. But right now that hasn't passed any place at all. Okay?
Do you
So
mind if I add one more thing?
Yeah.
I think it's also important to mention that in 2024, the American Bar Association, which is the biggest organization of lawyers in the country, the biggest professional organization of lawyers in the country, passed a resolution and declared that the time limit is not actionable. They decided, this is the, again, biggest organization of lawyers in the country, they all put their heads together and their conclusion was the time limit is not actionable, meaning when it was put on the ERA in the 70s, that was wrong. And so I also think, I hope I'm speaking slowly enough. I apologize. I sometimes let my heart beat faster than my mouth can speak. But whoever had asked that question, I encourage you to also think about times in which elected officials were wrong. The time limit was wrong. That was wrong. That wasn't right, right? And so, right, of course, that is the version of the ERA that passed Congress, right? But it passed Congress with a time limit because of the pervasiveness of patriarchy, right? That's why there was a time limit put on the ERA when there wasn't for the 27th, the most recently ratified amendment. So I guess I always encourage folks to really think about, like, just because a politician did something doesn't mean it was ethical or right. And just because something passed, like this time limit, doesn't mean that it's equitable, right, or actionable. And, I'm not a lawyer. I'm a historian. So I can't speak to the law. But that's why I turn to organizations like the American Bar Association, which most folks would agree with me there. And they said it's not actionable. So I'm not a lawyer. I'm going with them. That's my final point, I guess, on the time limit. I hope that makes sense.
thank you very much, Molly.
What can we do? I mean, you're
This
saying
is
wait
my-
until next year.
This is my one suggestion. If we have the American Bar Association coming out and issuing statements, why isn't the LWVUS coming out and setting? So what we can do is we can decide that within our own organization, we can get the LWVUS to take a strong position on this and advocate for it. That's one of the places where we have access and to the some political capital that could be used.
Yeah. And culture. Yeah.
Yes, this is a nonpartisan statement, but I want to make sure that it gets out. That those of you who live in the 11th congressional district, there is, and anybody, Morris Township, but there are others, you know what district you live in, I hope.
Yes.
But a week from today, there is an election.
It's already going on.
Yes, the early voting is going on, but the election day itself is April the 16th. Where we will be voting for who is to take Governor Sherrill's place in the House of Representatives. So it is very important, whatever you think, the two candidates are, one is a Republican, one is a Democrat. And it is very important, whatever you believe, to make sure you vote.
There is a third candidate.
Yes, Mr. Bond is the third candidate. He's an independent. And then there will be, believe it or not, another election next fall
In November.
to do this all over again. But it is important between now and November that you vote and choose who you want to be in the House of Representatives. So whatever your political affiliation, and this is an election, not a primary, so you can vote. I urge you to come out and vote, and I'll see you there because I'm a poll worker, so.
That sounded very league-like to me. It was
Before
very-
we wind this up, I
Wait,
want.
Molly had something to say right
Okay,
before.
yes, go ahead, Molly.
Oh, to whoever just spoke, I thought I was muted. I said rock on because she mentioned that she's a poll worker, and I love that. So that's all I had to say.
Very good.
I'd like to lead, can I lead with a quote from the Bar Association, since Molly brought it up?
Yeah.
They, this was at an annual convention of theirs and they adopted a resolution and it says, as constitutional scholars point out, when 38 states have ratified an amendment, that amendment automatically becomes part of the Constitution, whether or not the amendment is so published and certified. And Lawrence Tribe, as I cited before, and Kathleen Sullivan, top constitutional lawyers, had issued a statement the same day as Biden's statement to the same effect that says, and cites Article 5 of the Constitution, that when ratified by legislatures of 3/4 of the state, it is added to the Constitution. So nothing in Article 5 makes the Constitution binding contents depend on any further official action by any branch of the federal government, whether Congress or judiciary, or indeed the executive, meaning the archivist.
Thank you.
Well, before we close, I want to make an announcement, and that is AAUW is having a special program on Monday, April 13th on human trafficking in the shadows of the World Cup, the myths and the realities. And this will take place at the Madison Public Library in the Chase Room, which is their large meeting room, at 7 p.m. Coming up this Monday. The speaker is Michelle Leslie Stegman, Esquire, General Counsel for NJCAHT, which I'm assuming is the Coalition Against Human Trafficking.
Yes, and that is a state, and there is the New Jersey Coalition
Right.
Against human trafficking, so it is a local movement that is very active.
Not to draw this out, but can I just say what you said about having the National League get involved, there is strong support for the ERA, always has been, and right now Rebecca Goldman, who's a staff member at the National League, is involved in it, and I've done some work, back and forth with her. And in fact, after the deadline passed in '82, for a year, the league had a national committee talking about what we do next, and luckily I got asked to be on that. So I mean, I know that there's strong commitment, but given the league process, of course, and what studies are adopted and positions are focused on and so on, it's always good for the National League to hear from other leagues that they want more attention paid to certain issues, so.
Thank you.
Yes,
Please do.
I'm just gonna circle back a little public announcement. You circle back to SUFs. So on May 8th, it will be on PBS. Yes, PBS. Friday night.
Oh, no, what will be on PBS?
Stuff will be broadcast on PBS.
Wonderful.
Yes, on Friday, May 8th.
Thank you.
Okay.
Well, so I want to thank everybody for coming. Did anybody else have any questions or comments before we bring this to a close? Well, I am really, really pleased that we've had this opportunity tonight to move this to come to greater understanding about where we are and where we stand with this, and that it's not hopeless. A little personal privilege. I want to say that I did meet Alice Paul personally in 1965 when I was a college student, and I went to Washington D.C. with a friend of mine who was an international student from Germany. She had her family arranged for a private tour of the Capitol building for us and of the monuments. We went to D.C. and then he said to us, "Well, would you like to meet Alice Paul?" At that point, I said, "I don't know who she is." So she was still living in the Belmont House, and we went there, we had tea with her, and she showed us the banner that they dropped in the public area of the Congress. Now, I was a feminist before that, but that's what anchored me.
Wow.
Wow.
So thank you. What we have to do, we have to be out of this room by 8:45.
Okay.